before the court today, and I've reviewed the parties' pleadings. There appears to be a disagreement about the form of the order, and this, of course, deals with the court finding a violation of the Public Records Act by Lewis County. At the merits hearing that we had, there's going to be an upcoming penalty hearing. But as I understand it, the parties attempted to confer, but were unsuccessful in reaching an agreement as to the form of the court's order. Is that accurate, Mr. Thomas?
Yes, Your Honor.
Mr. Eisenberg?
Yes, sir.
And so the court had reviewed both of your, Mr. Eisenberg had Appendix A and Appendix B. Mr. Thomas, you had your proposal. I think many of the points Lewis County made have some merit. I did have a specific question, and I will give you both an opportunity simply to address the court as to your views as to why your order is the proper order. Ultimately, it's the court's decision since it's the court's ruling, but I did have a specific question to Lewis County. In the attachment 1 on page 7, paragraph 23, there's a finding that Lewis County's requesting the court make that says the following. It's the second sentence. Though Lewis County would have produced the documents, it failed to communicate an intent to do so, denying the request until the lawsuit was served. It's the first clause that I have a question about. So I'd be interested to hear your argument as to that first clause.
Thank you, Your Honor. So the reason that I believe that that was the part of the basis for Your Honor's ruling was that Lewis County's evidence at that merits hearing included declarations from both Casey Mowerman and Kim Amrine that had indicated an intent to keep working on this request and had offered, by way of explanation for not having produced records and not having communicated to the plaintiffs, that they were overburdened with other work. And Your Honor certainly ruled that notwithstanding those facts, there had been a denial. But in light of your further ruling that you were denying Mr. Thomas's motion to strike that material or motion to disregard it as irrelevant, I thought Your Honor had credited those assertions and that you were finding that notwithstanding the fact that they intended to produce records and that they had not done so, nor had they communicated that intent to the plaintiffs, and that was the basis for the denial, because it was final action, because plaintiffs would not have known that more records were coming, and that furthermore, that it was the filing of the lawsuit that substantially caused them to produce that first installment. And that is what I thought Your Honor was ruling in light of the sort of combined effect of your treatment of the motion to strike and your ruling on the merits. And if I'm mistaken about that, then I'm happy to have Your Honor revisit that. That's what I thought you were ruling. Thank you.
Thank you. Mr. Thomas, do you have an argument you want to make regarding the court's question that I posed to Mr. Eisenberg?
Yes, the record is actually in contrary to that position. First of all, the public records officers said that they weren't diligent in responding. And second of all, in addition to saying that they weren't diligent, they said they chose not to respond because they were trying to produce the records. So there was no intent to communicate at all. And that's actually from the declarations, and that was argued during the merits hearing.
Thank you. Well, I do want to give you both an opportunity to make your respective positions as to why the court should adopt your proposed order. Mr. Thomas, I did review that, but do you want to make additional argument?
As to that point?
No, as to maybe the more responsive way to do this is Lewis County filed their objection to the form of yours and had prepared in their attachment 1 their version. I did have that one question regarding paragraph 23 on their proposed page 7, but do you have objection to the form of their proposed order?
I would like to just state that it's not their proposed order. It actually says that it's presented by me, and they kept my name on it, which is inaccurate. So the
record will reflect that.
I do have objection to their proposed order, and I think we outlined it in our reply. First of all, Lewis County argues that there's only one violation, and this court found a violation for both plaintiffs. The complaint listed both plaintiffs in the caption. The complaint listed both plaintiffs as a party to the lawsuit. Even Lewis County's response to the merits, and it's copied, the caption's actually copied in the reply, says that it's to Mr. Green and Mr. Cortland, and there's a semicolon between the two showing that there's an intent to use independent clauses to identify them both. It identifies them as plaintiffs underneath it. It also says, comes now, defendant Lewis County through its counsel submits this response to plaintiffs, and that's in the plural and possessive amended opening brief. Lewis County doesn't even believe its own arguments here that there's only one violation. It believes that there's two plaintiffs and that they both submitted that request. And under the law, each person under 4256-550, the plain language of that says that each person is entitled to a violation. And in fact, Washington courts have found, and this isn't applicable here, but Washington courts have found.
Mr. Thomas, I only want to let you know that while I appreciate you attempting to be efficient, your speed is going quicker and quicker. And I imagine in a moment the court reporter is going to have a difficulty, if he's not already, with keeping up. So please be conscious of that.
And Washington courts have even found that class actions are appropriate in the Public Records Act because the rules, the civil rules in general, apply to the Public Records Act, and so there's nothing prohibiting two plaintiffs making the same request, and there's nothing prohibiting under the plain language of the law and the court rules two separate violations here. And in fact, this court actually identified a violation for the petitioners when it stated, but this court is satisfied that based upon the record that Lewis County did withhold these records from petitioners. And it said it again, and it said, it took, quite frankly, in this court's view, the filing of the lawsuit on September 1st to produce the records to the petitioners. And so plaintiffs do vigorously argue that there are two separate violations, one for each plaintiff. And that's the first point. The second point that plaintiffs take issue with is that Lewis County tries to argue that there's some sort of qualification on this. And they cite a lot of case law, and they say, look, they're only partially prevailing, and we need to go forward with this issue of prevailing. And they cite Sanders versus State, which is a Washington State Supreme Court case from 2010, among other cases. And even Sanders versus State defines that it says there is no reason why the definition of prevailing under the PRA on appeal should differ from the definition at trial. We therefore focus on the hearing on whether the right to inspect and copy or the right to receive a response. And that's from Sanders versus State. And as this court ruled that there was a denial of the right to inspect and copy. So there's only one issue in front of this court, whether there was a denial of the right to inspect and copy. This court found a denial of the right to inspect and copy. Plaintiffs are prevailing on all issues. It's pretty clear from the case law. Plaintiffs or defendants try to misconstrue case law, but it's really clear that The question of a prevailing party is whether the record should have been produced upon demand, and the record should have been, the court found in this case that the record should have been produced upon demand. And then next, plaintiff takes issues with Lewis County argues that the prevailing party status is still to be determined because about the issues argued at the penalty hearing. They say that the issues from the penalty hearing and whether we successfully argue factors, Yusufian factors, affects the prevailing party status, and that's simply not true as a matter of law. The prevailing party status is determined at the merits hearing because under the plain language of RCW. Let me back up, I'm sorry.
Yusufian factors affects the prevailing party status, and it's simply not true as a matter of law. The prevailing party status is defined in RCW 42.56.550 section 4, and that mentions prevailing, and the case law construing the prevailing party status clearly says that it is defined at the merits hearing. There are no other issues for this court to decide. And so when defendants talk about the prevailing party status needs to be decided at the penalty hearing, or that plaintiffs are only partially prevailing, that's simply not true as a matter of law under well-established Washington case law. Next, Lewis County wrongly seeks to include facts that the court did not find at issue at the merits. And the court actually did say that these facts could influence the penalty, but did not find these facts affect the merits hearing at all, including I'm sorry, I lost my place. Let me skip that and I'll come back to that. But the next issue is and that they're asking this court to make extrajudicial findings. For example, that the records were emails which needed to be searched through to find documents responsive to this request, reviewed for possible redaction, and produced. And they cite this twice in their proposed order, and that was never argued. That would be an extrajudicial finding by this court. And so those are the issues, and we'll let defendants respond.
Thank you, Mr. Thomas. Mr. Eisenberg?
Thank you. I'd like to start with that one because I think it's more cut and dry. In the evidence before Your Honor at the merits hearing, you had declarations that incorporated responses to interrogatories as part of discovery. And in them, Casey Merriman and Kim Amrine describe what they were working on related to the request. And one of the things they say is the next step is to go through the thousands of responsive emails, review them, and then produce them if they're relevant. So, I think that's what's specifically in the evidence before Your Honor, and the reason I asked for it to be included as a finding is relevant to a specific argument of law that I'm making in the motion, which is, I don't believe that we had addressed to Your Honor as part of the merits hearing which records were denied. I was concerned that the language in Mr. Thomas's order and my conversation with him was predicated on a belief that Your Honor ruled that all potential records responsive to this request were denied as a result of the denial that you found. And I think that issue was just not raised at that hearing in a way that Your Honor ruled on it, because we didn't talk about specific records. And I argued, as you saw in the briefing, that the way in which Mr. Thomas argued for the violation sort of suggested that it was a more limited denial than that, because he referred specifically to records that were already gathered, records that that Lewis County had in its possession and ready to give out, but had not done, nor had they communicated seeking an extension until the lawsuit was filed, and then 1 week later, an installment comes out. So it was based on that specific line of argumentation that to me suggested that, if anything, Your Honor had actually ruled that the denial of records was those records which, the production of which was caused by the filing of the lawsuit, which would be perhaps the first installment of records. Or more broadly, perhaps Your Honor ruled that those records which were reasonably available and ready or could have been produced by the time of the lawsuit was the denial. But I did not understand Your Honor to be ruling at all really on the issue of whether all of the records were denied. The reason that that is relevant is, of course, that you have a per record per day penalty, so that's important. But more so, the prevailing party question turns on that. I respectfully disagree with Mr. Thomas's position that the court is ready to do prevailing party analysis, because if Mr. Thomas's position on behalf of his clients is that all of the records were denied, and Lewis County's position is that not all of the records were denied, and Your Honor were to rule in Lewis County's favor on that point, then Mr. Thomas's clients would not have prevailed on an aspect related to their right to receive records. They would not have been denied access to the records that Your Honor found were not part of the denial. And he mentioned the Sanders case. In Sanders itself, they find that only some of the records were unlawfully withheld, so there was no unlawful denial as to those records, and therefore those records don't account toward the prevailing party status. I think they use the word deeply discounted, that they say that the prevailing party spoils, if you will, which is costs and attorney's fees, should be deeply discounted by the fact that Justice Sanders had prevailed on only a small portion of the records that he argued should have been produced. So too here, if it is the case that Mr. Cortland and Mr. Green argue that all of the records were denied, but Your Honor finds that only some of the records were denied, then their prevailing party costs and attorney's fees ought to be discounted under the case law cited in my brief in proportion to those issues on which they prevailed and not in proportion on those that they did not. I don't want to make this sound as mechanical as perhaps I'm making it sound. Your Honor has broad discretion to divide the case into issues and then to decide who prevailed on what and to apportion costs and attorney's fees accordingly. That's exactly what happens in the Sanders case, and the Supreme Court affirms the trial court's treatment of the issue in that matter. I'm only saying that we haven't gotten there yet. I'm just asking for the order to not reflect that plaintiffs prevailed on all actions in the case when we haven't decided which records were denied yet, and therefore we don't know who's fully prevailed on all the issues. Thank you very much.
You're welcome. Mr. Thomas, I give you the last word.
Okay, I'll try to make this quick, Your Honor. Lewis County never argued that there was only a partial denial. Plaintiffs argued that there was the catalyst theory, that there was a complete denial, that it took the lawsuit in order to get even an initial production of documents. Plaintiffs argued that there was a complete denial under Hobbs. Plaintiff even went to the length to ask this court to look at find mandatory judicial notice under Hobbs that there was a complete denial. And so Lewis County can't come up here and make new arguments and try to finesse new arguments into its proposed order that it never made during trial. It never argued these things, and the record is absolutely clear that Lewis County never argued that we were not the prevailing party. If you look at the briefs, we actually argue in the title that we are the prevailing party, that Mr. Cortland and Mr. Green are the prevailing party. Lewis County never disputes that. Lewis County never disputes that only part of the record, that all the records were not denied. They don't make an argument that only some of the records were denied and that it was only the first set of records. And furthermore, if this court wants to, it doesn't make any sense that only the first records would be denied. Mr. Cortland and Mr. Green did not know that Lewis County would ever respond, and that was the basis of this court's ruling. If they did not know that if Lewis County would ever respond, then how could only a partial amount of records be found to be denied? They were denied access to all records because they did not know Lewis County would need to respond, which is why they filed this lawsuit. And that's my argument. Thank you.
Thank you. I appreciate that the parties attempted to confer. However, it's clear that there were issues that both parties maybe did not become fully aware of until we got to the point of trying to prepare an order. But the court endeavoring to make a ruling that's helpful to the parties, that captures what the court decided, the form that this has come about is not as helpful as I would have hoped. While I've given a lot of consideration to the arguments Mr. Eisenberg made, I am going to sign the proposed order that Mr. Thomas has prepared. I think it most accurately captures what the court did rule. And this matter will be set over for the penalty hearing that's already been noted, and there will be an opportunity to address these issues. But I'm prepared to sign, Mr. Thomas, your order.
Thank you.
You're welcome.
I have a copy that I just don't have a pen on me. And I think I might have already signed this.
May I ask just again, I'm not attempting in any way to undermine your order. I just want to know what to do going forward. So then, does this order mean that Your Honor has found a denial of all of the records that were, all of the records that this request produced, including those produced well after the September 1st installment? Or is that issue still open?
Well, the court is making the finding that absent the filing of the lawsuit, these records were not provided. I think these issues, to my mind, come more to what is the appropriate penalty based upon the action of Lewis County. Once the lawsuit's filed, they clearly start producing records. That's going to go into how the court looks to what the appropriate penalty is for the violation that was found. But the court's finding is that absent Mr. Thomas, on behalf of his clients, filing this lawsuit, it's unclear when, if, whatever these records would have been provided. And I understand the county's taken this position that they would have at some point, but based on the record that I have before me, it's unclear. It's unclear. I think there's the claim by Lewis County. That's why I asked the question about your proposed paragraph 23. That was clearly an argument from the county's perspective that ultimately, at some point in the future, they would have got around to providing these records. But the court's finding is they didn't, without the lawsuit being filed. They waited too long. They blew past their deadline. Cortland and Green both attempted to have communication with Lewis County. That didn't result in anything. There was a period of time they waited, and once they filed the lawsuit, then Lewis County, realizing, I would imagine, that they had failed in their duty to get these public records to the plaintiffs, then proceeded to try to accommodate those requests. To my mind, and I'm open to hear arguments at the penalty phase hearing, but to my mind, all of that goes towards what would be an appropriate penalty, which I'll determine after hearing both your arguments for this violation. But hopefully that helps clarify your question.
I think it does. Thank you, sir.
You're welcome. Mr. Thomas, did you have any clarifying questions?
No, thank you, Your Honor.
Thank you.
Actually, by the same token, again, I don't wish to make further argument to Your Honor on something that you think is closed. So do you wish there to be any further argument for the penalties hearing on the issue of whether Mr. Green and Mr. Cortland independently and separately should be receiving a remedy, or as opposed to a joint remedy?
Well, I'm certainly not going to tell Lewis County how to make their argument. I don't know ultimately whether it's a good use of the county's time to respond to that argument, because clearly there's a connection between plaintiffs. I think that's why the case was filed with the both of them together. So I guess what I would say is I'm open to both sides presenting whatever arguments they think the court should take into account. I'm proceeding with the thought process that this case, as pled, involved two individuals.
Thank you, sir.
You're welcome. Ms. Thomas?
No, thank you, Your Honor.
Very well. Well, that'll be all for today.
Thank you.
Yes, sir.
Thank you both.